Bonjour, Baki. Good morning, good afternoon, good evening from Shanghai. This is Lin Yang from the Hong Kong International Arbitration Center. Today, I'm so delighted to deliver the welcome remarks at the HKIAC event at the Paris Arbitration Week. Paris is an amazing city. I still remember about 15 years ago when I was a visiting scholar in Paris, where I lived in a small room close to the Jardin du Luxembourg. Yes, like many of you, I'm really looking forward to visiting Paris again soon. So for today's webinar, the topic is about the interim measures arrangement. I believe all the participants would agree that interim measures is one of the most important tools in international arbitration. Not only will it facilitate the smooth conduct of the arbitral proceedings, but it also safeguards the enforcement of the final arbitral award. And traditionally, parties to HKIAC arbitrations have multiple ways to get interim measures before Hong Kong courts, emergency arbitrators, and arbitral tribunals. And for most arbitration institutions worldwide, parties may obtain the interim relief in the similar ways. However, since 1st October 2019, for Hong Kong-seated arbitrations, another unique way has been in place for parties. I mean, for parties to Hong Kong-seated arbitrations can also get interim measures before the mainland courts, thanks to the Hong Kong-Mainland China Interim Measures Arrangement. So, what is the Interim Measures Arrangement? I can give you some background for those who may not be familiar with it. Before 1st October 2019, parties to arbitration worldwide, including those seated in the mainland, can get interim measures before the Hong Kong court, because the Hong Kong Arbitration Ordinance allows the parties to do so regardless of their seats of arbitration. In contrast, the parties to the arbitration outside of mainland China, including sitting in Hong Kong, cannot apply for the interim measures before the mainland courts, except for maritime arbitrations. This is because the legal basis for mainland Chinese court to grant interim measures in support of arbitral proceedings seated outside of mainland China was extremely limited. Then, what change has been brought by the interim measures arrangement? That is, the interim measures arrangement has so far allowed Hong Kong to be the first and the only jurisdiction outside of mainland China where parties to arbitrations with Hong Kong seat can apply interim measures before the mainland courts. So for this important instrument, I should emphasize 4 significant dates. The first date was 2nd April 2019. The SPC, which stands for the Supreme People's Court of the People's Republic of China, and the Hong Kong Department of the Bureau of Justice, signed the instrument in Hong Kong. And on 25th September 2019, the SPC and the Department of Justice of Hong Kong jointly announced the 6 eligible Hong Kong arbitral institutions. Among others, HKIAC is one of them. And I should remind you that according to the arrangement, only parties to arbitrations administered by those 6 Hong Kong arbitral institutions are eligible to apply for interim measures before mainland courts. Then, on the next day, the SPC published a note on the interpretation and application of the arrangement. This note is very important because it provides a useful guideline for both arbitration users and the mainland judges. Therefore, for those who wish to rely on the arrangement to get interim measures before the mainland courts should read the arrangement and the note together carefully. I should emphasize again that all the documents issued by the SPC include the SPC note and the 12 templates issued by the SPC were drafted in Chinese. HKIAC, we have helped to translate all those documents into English. For audience, if you like to read the English and the Chinese version of those documents, please visit HKIAC's website. And then this arrangement came into effect on the first day of October in 2019. Over the past near 2 years, HKIAC has gained rich experience on the arrangement. According to my understanding, HKIAC is the only Hong Kong arbitration institution so far which has circulated the data and frequently asked questions regarding the arrangement. Take our frequently asked questions, for example. It contains the background information, implementation of the arrangement, and answers to practical questions. For global users' convenience, it was drafted in 5 languages: English, Chinese, Korean, Russian, and Japanese. So it has been updated regularly. So for today's audience, you can easily get those documents on HKIAC website. And I also believe Sarah Grima, the Secretary General of HKIAC, will be introducing the data concerning the arrangement from the perspective of HKIAC later. So for today's panel, we have very diversified as distinguished speakers from different cities, including Hong Kong, Beijing, Shanghai, and of course, Paris. Let me introduce them with pride. Mr. Dong Chungang is a partner of Jingtian Gongcheng Beijing office. I understand Mr. Dong's team has experience in applying for interim measures before mainland courts under the arrangement. And Cao Hennessy is the council member of HKIAC and also the member of HKIAC's proceedings committee. Cao also is the senior vice president of the litigation, investigation, and regulatory affairs at Airbus. Mr. Niels Ellison is the partner at Sherman Sterling in the international arbitration practice. He currently serves as a vice chair of HKIAC and the chair of the HKIAC proceedings committee. Sarah Grima is my boss, the Secretary General of the HKIAC. And the last but not the least, Mr. Anton Ware is the partner at the Another Porter, and he practices in the area of international arbitration with a focus on the Asia Pacific region. So today's webinar has 2 parts. The first part is the panel discussion and will be moderated by Anton. And for the second part, after the panel discussion, we would have 10 minutes for Q&A. So for today's webinar, I would encourage all the audience to raise questions by using the function of Q&A on the bottom of your screen. So Anton, now I would like to leave the floor to you for the panel discussion. Thank you.
Thank you so much. Good morning and good evening, everyone. And thank you, Dr. Yang, for that very helpful overview of the arrangement. I also want to thank HKIAC for hosting this event and for giving me my first opportunity to participate in Paris Arbitration Week from Shanghai. The arrangement has now been effective for 2 years, and we have the benefit of real data on its implementation and use. HKIAC has been at the center of these developments, and we have the pleasure of having the current Secretary of HKIAC, Sarah Grima, with us here today. So Sarah, I thought we would get started by checking in with you to see how the arrangement has been used in practice. What are you seeing at HKIAC?
Thanks a lot, Anton. As Ling pointed out, what the arrangement does is it means that parties to arbitrations seated in Hong Kong and administered by one of the eligible institutions, of which HKIAC is one, are now able to apply to the mainland Chinese courts directly for interim relief, something that was not possible before, only in very limited situations. So it's a really important change. And we have a role in this process. What we need to do is when an applicant is making an application to a mainland Chinese court, they need to supply a letter from the HKIAC confirming that we are administering the institution. And upon receipt of a complete application, we will issue that letter within 24 hours and we don't charge a fee. So we issue that kind of confirmation in arbitrations that we administer under our own rules. But I think it's also important to know that we also issue that confirmation in cases that we administer under the UNCITRAL arbitration rules. And there have been 2 applications under the arrangement, under the UNCITRAL rules that we administer, and the applicants were successful in those applications to the courts. So to date, we have processed 50 applications under the arrangement, and I have here quite a useful slide. And we track the information under the applications very closely, and based on the information that we have currently available, I can share what we see. So we have seen 47 applications for preservation orders over property. We've seen 2 applications with respect to the preservation of evidence and 1 with respect to the preservation of conduct. And those are the 3 types of preservation measures that are available from the courts in mainland China under the arrangement. And it's a little bit different going the other way with respect to interim relief available from the Hong Kong courts, given that the Hong Kong court system is a common law system and the mainland Chinese system is a civil law jurisdiction. So all of the applications that we've seen under the arrangement were made in arbitrations that were already commenced. And I say that because under the arrangement, you can apply for interim relief to the courts in mainland China even before you commence your arbitration. But if you are successful in your application, you must commence the arbitration and supply a letter of confirmation from HKIAC to the court within 30 days, failing which the interim relief will be discharged. We are aware of 30 court decisions in which preservation orders over property were issued. And you will see here on the slide, the 3rd point down on the right, the total amount of assets that all of those court orders preserve comes to 10.9 billion RMB, which is roughly the equivalent of 1.7 billion US dollars. So I think that you can see immediately how compelling and how significantly advantageous it is in a commercial sense, the new arrangement, because what it means for those 30 proceedings is that the applicant has secured freezing orders over the assets of the respondent, which gets them much further down the line towards enforcing an award coming out of those proceedings. You will see here a list of cities in mainland China. Those are the cities in which the courts are located, to which the applications have been made. All of the applications must be made to an intermediate people's court in mainland China. And the rationale behind that is because it is the intermediate people's court, that's the level of court to which you would make an application for the enforcement of an award. And because the preservation measures under the interim measures arrangement is concerned with ensuring the effective enforcement of an award, it is considered that it should be the same court to deal with the preservation applications as well as the enforcement of an award. Also, with respect to the choice of courts, applicants need to potentially make a choice. You have to choose the court that is the location of the residence of the respondent, or where the assets are located. And if those are 2 different jurisdictions, then the applicant will need to make a choice. It cannot file 2 applications simultaneously at different courts. You see there the bottom set of data is with respect to the provenance of the applicants and the provenance of the respondents under the applications that we have seen. And this is quite interesting because you see here that 3/4 of the applicants are foreign entities, so incorporated outside of mainland China, but 1/4 of the applicants are mainland Chinese parties. And perhaps what's more interesting is the split between the respondents under the arrangement. So it's roughly 1/2 respondents are mainland Chinese entities, and the other half are entities incorporated outside of mainland China, but which own assets in mainland China. So we see there that not only are all parties benefiting from the arrangement, but the impact of the arrangement is having an effect both on mainland Chinese parties and foreign parties. Under the arrangement, the courts are obliged to deal with the applications expeditiously and as soon as possible, which of course makes sense given the urgent nature of the applications. So with respect to what we see on the cases before HKIAC, we have measured the time from the filing of the application to the issuance of the decision by the court. And the average time that it has taken the courts that we see is 20 days, and the median time is 8 days. And I would suggest that it's perhaps the median time that is more accurate or more predictive of what you might expect. And I say that for two reasons. So that's because the median measure isn't skewed so much by the outlier cases. And because the Interim Measures arrangement came into effect in October 2019, it was before the COVID-19 pandemic. And in those early months of the Interim Measures arrangement, there were some major lockdowns happening in mainland China that affected the courts. So we did see some delays early on, but I don't think that people would be seeing the same kind of delays at all nowadays. I'll just conclude, Anton, with a couple of points on our practical experience under the arrangement. So we issue the letter to the applicant, and then typically what happens then is the applicant will file the application directly to the mainland Chinese courts, which is somewhat of a departure from the usual practice in mainland China, where it is typically the arbitral commission that will transfer the application to the courts. In about 2/3 of our cases, the applicant has filed the application directly to the courts, and that's as foreseen under the SPC interpretation that Ling referred to, which is the most authoritative piece of guidance that we have on the implementation of the arrangement from the most authoritative court in mainland China. But in about 1/3 of the cases we will transfer the application to the court, or once the applicant has filed with the court will ask HKIAC to then transfer the application, and that's fine, we do that, and we try to do that as quickly as possible so no time is lost. Sometimes we will receive requests from the mainland Chinese courts for extra information or to confirm certain information. For example, we had one case where the applicant wanted to extend the preservation measures, and the court asked us to confirm that the arbitration was ongoing, and that was no problem, we did that. Sometimes we're asked to confirm information that perhaps we're not in the best position to do that, but we will confirm based on the record in front of us to the extent we can, and even in situations where we've issued some qualified confirmation that has, in my opinion, proved to be useful to the process. So I'll stop there. Thanks, Anton.
Thanks so much, Sarah. That's very interesting. I was particularly struck by the data point that roughly half of the respondents in these applications have been non-Chinese parties with assets in mainland China. That certainly is outside of my expectations. I had one question for you, Sarah. Does HKIAC do, or what sort of scrutiny of an application does HKIAC do, if any, when it receives the application before submitting or issuing the letter?
So we scrutinize the application and make sure all of the required documents are supplied. And also there may be a question as to whether or not HKIAC would be competent to administer the arbitration. Of course, any decision in that respect by HKIAC is a prima facie decision, so it is a low threshold. We have not had to do that in terms of a situation where we were concerned that we didn't have competence to proceed as we were requested in the arbitration. So that hasn't been an issue, but we would be able to deal with that quickly.
Excellent. Thank you so much. So why don't we then take a step back and shift our focus to what is the real meaning of this arrangement for the parties, for the end users of arbitration. And for that, I wanted to begin first with Carl, who can bring the in-house perspective to bear. Carl, what do you see as the benefits of the arrangement from this perspective of the parties at the time when they're negotiating their contract and their dispute resolution clause?
Thank you, Anton, and thank you to the HKIAC for having invited me. It's a delight to be with you again. The question is the right one, Anton, because fundamentally what we're trying to achieve, whether it's at time of contract or at the time the dispute arises or as the dispute proceeds, is two things. We're trying to preserve the relationship between the parties. It's nearly always the case, especially in our industry, and I would suspect it would be the same in industrial for industrial concerns across the practice, that we have a long-term relationship with the party on the other side. That may involve continuity of supply, continuity of delivery, and given the way that the supply chain works for us in particular, the slightest disruption is of great importance to us. And so it's of equal importance to both parties at time of signature that we have a means to assure ourselves and to reassure one another that conduct, that assets, that evidence will be preserved in the event of a dispute. It actually helps reassure the parties as they reach the second point that I'd like to emphasize, which is it actually promotes settlement, because that kind of certainty takes out of the hands of parties at a moment of perhaps anger, a moment of aggressive temptation, the desire to try to use leverage in a way that may actually disrupt the relationship long term. So for us, fundamentally, we would be careful about selecting to use the arrangement, but its existence and the fact that it is known to both parties from the beginning does a great deal to actually encourage the parties to act in good faith, to avoid the need to use it at all. And if it is used, it then returns the dispute to its essence rather than making it one of leverage or tactics.
Thank you, Carl. I guess just to follow up quickly on that last point, do you have any concerns about the use of asset freezing orders under the arrangement being exactly that, a tactic or an attempt to gain leverage over your side or over the opposing party?
I suppose the temptation to use tactically an arrangement like this or any kind of interim measure is always one that arises in theory, but I'll tell you in practice that I've rarely seen that. In other words, what this does achieve is usually to balance a playing field rather than to unbalance it. The careful scrutiny given in my experience by the PRC courts to these applications does look at the need for the order in those terms. And it's not been my experience that the PRC courts wave them through, but rather what I've observed, both in cases that we've looked at and also more objectively across the space, and I'm sure that other panelists will have a view on this, is that the scrutiny really does bear on is the freezing order necessary in order to preserve the status quo, that there can be a balanced and non-tactical view taken by the arbitral tribunal.
Thank you very much, Carl. Let me go to Niels then and get your perspective on how the arrangement has been received by your clients. And in your experience, is the arrangement having an impact on their choice of the seat of arbitration?
Thanks, Anton, and good morning to everyone in Paris listening into this webinar. It's a couple of different points, and I would start by saying that you can't underestimate the importance of this arrangement for the clients that we are advising. And in my capacity as an arbitration partner at Sheldon & Sterling in Hong Kong, I advise Asian clients, European clients, and US-based clients. And for all categories, this has really been a game changer in many ways. And just to recap 3 points that has been touched upon why this is so important. The first one being, of course, that with the arrangement, Hong Kong is the only jurisdiction outside of mainland China where you can actually get the support from the Chinese court for interim measures. If you have the seat of arbitration in London or Singapore or Stockholm or Paris, you cannot get interim measures from the Chinese courts, number one. Number two, if you get interim relief from your tribunal, that interim relief is not enforceable in China. So you really are dependent on getting interim relief from on the ground in mainland China. And third point, it is not only interim measures intra partes. You can also apply for ex parte interim relief. So it's an extremely important benefit for parties that have chosen to have the seat of arbitration in Hong Kong when they have a dispute with a China connection. And as we have seen from the statistics, this is not only when you are contracting with a party based in mainland China, but also when you're contracting with a party that might have assets in mainland China, even though that party might not necessarily be based in mainland China. So it is indeed very important, number one. And the second point I wanted to touch upon is, do we see this affecting the choice of seat? And the answer to that is we already do see a change in the drafting of arbitration clauses. And I mean, to put this in context, that already before the arrangement, of course, there were a large number of multinationals that already had Hong Kong and the HKIAC as their default dispute resolution choice for contracts with Chinese entities or for Asia related contracts and deals more broadly. But what we have seen with the arrangement is that, whereas before, if there was pushback on Hong Kong as the seat, those companies that had Hong Kong as the default might quite easily have agreed to something else before, because what you were giving up, even in a deal with the China connection, was not that much before the arrangement came into place. Because as we all know, Hong Kong, Singapore, London, Paris, Stockholm, and other seats are to a large extent interchangeable. But so maybe you didn't get the same pushback. We also saw from clients that maybe had Singapore as the preference before the arrangement for all Asia-related matters, including with the China connection, that even though they saw the benefits of Hong Kong on a China deal, they still maintained their default choice of Singapore. But after the arrangement was put into place, we really see that companies that have already had Hong Kong as a preferred seat will push back more firmly when someone suggests a different seat for a China deal. We also see that, and I have had a number of technology companies, US-based technology companies from the West Coast that previously had always had Singapore as the default seat, has recently changed their template contracts, and we have advised them on that as well, to have HKIAC and Hong Kong seat with all license deals, for instance, with licensees in mainland China, to have this option when you need it. And we have even seen, which is quite encouraging, some US clients that were very set before on always, if they were tech companies, sticking to the courts of California, and if they were financial institutions to the courts of New York, actually coming around and warming up to arbitration. And I advised on a deal only last week, where a New York-based bank on a deal that had a lot of underlying assets in mainland China put in an arbitration clause with a Hong Kong seat and HKIAC arbitration, precisely to come within the scope of the arrangement if that would become necessary. So this is, I see this as really encouraging, and I see that it is changing the way in which clients think about the seat, and it does have a real impact.
Thank you so much, Niels. That your experience is similar to my experience as well. I know that when the arrangement was first announced, there was a flurry of commentary by many using the term game changer, that this would be a game changer. And it's encouraging to see that those predictions seem to really have proven quite accurate now that we have a couple years of experience under our belt. So let's turn then to looking at some of the practical issues that are involved in actually seeking interim relief from a mainland Chinese court under the arrangement. And for that, let me turn to Dong Chungang. And Chungang, I understand that your team has actual experience obtaining an interim relief order from a PRC court under the arrangement. Tell us about that experience.
Okay, thank you, Anton, and hello, everyone. In China, we are on public holidays today and tomorrow. Is Mid-Autumn Festival, probably the most important holiday in China for the family members and friends to reunite. So happy Mid-Autumn Festival. I would like to introduce, some experience of our team for obtaining a freezing order from a local court in Guangdong province in aid of our HKIAC arbitration. In that case, we first approached the court for a parole arbitration freezing order, as Sarah has just mentioned. But unfortunately, although this parole arbitration interim measure is allowable under Article 3 of the arrangement, it was refused by the local court. We don't take it as a discrimination against Hong Kong seated arbitration because, in practice, the PRC court rarely approves parole arbitration freezing order, even for domestic arbitrations in China. So that's normal. But as a plan B, we commenced arbitration, and our arbitration case was successfully accepted by HKIAC. Then we submitted an application to HKIAC for a freezing order under the arrangement. Thereafter, HKIAC issued a letter in a sealed package to us. The package was delivered to our office, and then we brought that package to the case filing department of the local court in Guangdong province. The court accepted our application and issued the freezing order accordingly. Like other mainland Chinese domestic arbitration cases, the court did requested us to provide security for the freezing order. So we purchased a litigation preservation insurance policy from an insurance company to satisfy such security requirement. During the whole process, we felt that the HKIAC Council was very helpful and very experienced in handling such kind of application. And on the mainland Chinese court side, we didn't notice any difference from other domestic arbitration cases in which we seek for interim relief. So I think this proves that the arrangement works very well in practice. Anton.
Thank you very much, Chungang. That's very, very interesting. So just to follow up on one of the first things that you said in this instance, you first tried to obtain the freezing order before you had commenced arbitration, so a pre-arbitration order, but that was declined. And you said that it's quite difficult in mainland China to obtain interim relief before the commencement of the main action. Why do you suppose that is?
I think that's a judicial policy issue. For most Chinese court judges, my personal speculation is, there is a big caseload, before the PRC judges. And another concern probably is they are not certain whether you will really commence the arbitration or not. If not, such kind of preliminary injunction must be discharged. Therefore, I think in practice, most PRC judges are very cautious and very concerned about such kind of measures, not only for Hong Kong seated arbitration.
Thank you very much. Now, it's been mentioned a couple of times that there are 3 different categories of interim measures that are potentially available from mainland courts under the arrangement. One of those categories, which has received some degree of attention, is what is known as a preservation of conduct order. And for many folks with a common law background, we have wondered, what does this mean? And does it mean that effectively that the PRC courts will grant a preliminary injunction, as we understand that concept in the common law? So I've got questions to each of our panelists on this issue, but I thought I would start with our PRC lawyer, Chun Gang. Can you give us a kind of a brief explanation of the concept of preservation of conduct under PRC law?
Yes, of course, Anton. My understanding of preservation of conduct is very similar to preliminary injunction under common law. And this basically means an interim measure taken by the PRC court to order a party to do something or prohibit a party from doing something. This concept was first introduced to PRC civil procedure law in 2013, following the amendment to the PRC civil procedure law. And the standards of such preservation of conduct were specified in Article 100 and 101 of the civil procedure law. So basically, the threshold is quite high, and the court, in most cases, will request the parties to prove at least two things. The first, the applicant must show the urgency, and irreparable harm may be caused failing such kind of preservation. And second, of course, the court will request the applicant to provide sufficient security. And more recently, the PRC courts have made some specific rules, especially providing guidance on the use of preservation of conduct, especially for intellectual property disputes.
Thank you very much, Chun Gang. So, Carl, if I could go over to you for the benefit of non-Chinese parties, how should they understand this preservation of conduct relief, and how does it compare, in your view, to a common law preliminary injunction?
It's the analogy is a good one, but I would layer another on top of it, if I may. It's in some ways the standard that is used, in my experience, seems to be more similar to a standard of specific performance. In other words, that the standard is quite high, and perhaps it should be quite high. I'll compare two scenarios in which we've considered this, and perhaps that will help illustrate why the standard must be so high and why security must be posted. One of the things I mentioned in my former remarks was the necessity of maintaining supply during the course of a dispute. So in a dispute with the supplier, we often will invoke a clause in our contract that requires both parties to continue to perform in the event of a dispute, even if the underlying dispute concerns the fact of performance. In other words, it seeks to provide a kind of certainty to the parties that neither will leverage a supply situation or a payment situation, for example. And in my experience, a clause like that is good evidence of urgency, such as the type that was cited as being necessary. But the absence of such a clause may contrariwise be cited as evidence for a lack of urgency, because it's a familiar concept as well. I don't know that a preliminary injunction fully captures the thoroughness of the analysis, because a preliminary injunction may concern similar circumstances, but I do find that common law courts, particularly in the United States, are more willing to grant a preliminary injunction because the remedy to remove the injunction is relatively quick and easy. If you are facing an ex parte injunction, where, for example, we've used this in the past to seize aircraft for non-payment, then you face a similar standard, in my experience in Western courts, particularly in the US, where, again, the urgency, the irreparable nature of the harm, and the requirement of a bond in sufficient amount is very similar indeed to what you're looking at when you look at conduct preservation remedies in the PRC.
Thank you, Carl. Niels, what has your experience been when it comes to preservation of conduct orders in practice?
Thanks, Anton. So a couple of observations, and the first one I think is that the powers under Article 100 of the PRC Civil Procedure Law to grant preservation of conduct is very broad indeed, and in that sense, I would say that the powers are similar to different types of preliminary injunctions in the common law context, although I fully share the views expressed by the other speakers that maybe the readiness of on behalf of the courts to actually make use of such powers might be a slightly higher threshold than what you're accustomed to in the Hong Kong courts, for instance, or English courts or US courts. But that said, I don't think that should discourage parties to try when they have a need for it, and in that context, the fact that the powers are formulated in a broad way is helpful, and it covers both what we would refer to as mandatory injunctions, i.e. that certain action must be taken, and prohibitory injunctions and anti-suit injunctions. So the powers are there, and I wanted to focus on one example that is particularly important from a Hong Kong context, because we have in Hong Kong a large proportion of cases at the HKIAC that concern private equity investments or private equity structures or other types of investment structures, holding structures in private companies, often involving entities in mainland China, Hong Kong, Cayman Islands, or the BVI. And in these type of contract setups where you have subscription agreements, investment agreements, share purchase agreements, and shareholders agreements, you often have a identically worded HKIAC arbitration clause and a Hong Kong seat. And in this context, I find it very encouraging that we have examples of very important injunctions, to use that term, issued by the PRC courts. We have one example quite recent example from 2020, where the Nanshan People's Court, just across the border in Shenzhen, issued preservation of conduct order prohibiting a shareholder who allegedly had obtained its shares in a invalid manner from registering the purchase with the relevant administrative authorities in China. And we had another similar case a couple of years ago where another shareholder in similar circumstances were ordered not to exercise any shareholders' rights. So I think these are examples where the courts have made use of their powers in a type of disputes that we have very frequently in Hong Kong, and therefore with the arrangement, this gives a very important supplement to the measures that you would typically seek in Hong Kong or the Cayman for interim receivers or different types of injunctions. You can now also use the mainland courts, where you often have the main operating assets in these investment structures. So I think this is very encouraging, and so parties should really assess the possibility of getting these type of interim measures as well when they are called for.
Thank you, Niels. That's very interesting and very helpful. Sarah, you mentioned in your remarks earlier that I think the overwhelming majority of the applications that HKIAC has handled to date have been for asset preservation orders. Does HKIAC to date have experience with requests for preservation of conduct orders?
Yes, thanks, Anton. We have seen one application for preservation of conduct order. The case was somewhat unusual. I'll explain why. It was a professional services agreement under which the claimant obtained claims from a third party for the respondent in respect of a mainland Chinese entity and was not paid by the respondent. and it approached a mainland Chinese court to obtain a conduct order restraining the third party from making any payments to the respondent. Now, we don't know what happened in the court proceedings. The court decisions are brief, but the result was not a conduct preservation order by the court, but rather a preservation over the assets of the respondent. So notwithstanding that the application was with respect to conduct over a third party, non-party to the arbitration, the court decision was with respect to assets over the respondent in the arbitration. So I think that we haven't yet seen a full range of applications of this kind, but that's the first one we've seen. And I think the comments of my panelists are really informative with respect to how the mainland Chinese courts approach these kinds of applications generally.
Thank you, Sarah. So we've talked quite a bit today about how the arrangement has given a competitive edge to Hong Kong, particularly vis-a-vis other arbitral centers outside of mainland China, such as Singapore and others. Now, in the meantime, very recently, the competitiveness of mainland Chinese cities and free trade zones as future centers of international arbitration was given a boost with the publication this year of proposed amendments to the PRC arbitration law, which, among other things, would import a model law-like regime for foreign-related arbitration seated in mainland China, and would also, for the first time, empower arbitral tribunals in mainland China to issue interim measures on their own. So one question I had was whether there's any risk that this package of reforms would diminish in any way the importance of Hong Kong as a seat of arbitration. And let me pose that question to Niels first, and perhaps you can answer from the perspective of your clients.
Yes, this reform in China, I think, is tremendously important, and we have seen a gradual strengthening of the arbitration market and arbitration seat, China as an arbitration seat during the last few years already, and this is a very important step in further strengthening, I would say, the competitiveness of mainland Chinese seats of arbitration. And I see that as a positive for all users of arbitration, because all multinationals are frequently facing situations where they need to, for one reason or another, choose the mainland as the seat, or it is the most appropriate seat for a particular contract. But I don't see this as really affecting the competitiveness of Hong Kong as a seat for many reasons. And I think that the most important one is that Hong Kong's status and recognition as a leading seat was not created overnight. It has been created over decades, and Hong Kong was the first jurisdiction in Asia to adopt the UNCITRAL model law, and has a very rich body of case law implementing the model law, has very strong judiciary with a specialist judge in charge of all arbitration matters in the High Court, and the Court of Final Appeal being one of the strongest appellate courts in the English common law world. And with that comes a recognition and a trust in Hong Kong and its arbitral institutions and the judicial system that I think will cause Hong Kong to remain a very competitive choice for not only for China related disputes, but for Asia related disputes more broadly for many years to come. And I don't think China improving its arbitration legislation impacts that. It's just that China becomes a more attractive option, but it doesn't remove the attractiveness of Hong Kong.
Excellent. Thank you very much, Niels. Chun-Gang, did you have anything that you would like to add from the perspective of a PRC lawyer?
Anton, it's quite interesting to hear that you, like foreign lawyers, are also interested in the amendments to the PRC arbitration law. As a Chinese lawyer and arbitrator, I feel the proposed amendments are quite encouraging. though I know there is still a long way ahead before they become legislation. On the tribunal's power to issue interim measures, I heard some law professors and lawyers have raised concerns, especially on the judicial scrutiny and also how to enforce such a big caseload, so many interim measures. Because in China, there are more than 200 arbitration institutions, which accept more than 1 million arbitration cases each year. So it will be a very complicated issue. And this reform, I think the reform will not would not only require the amendments to the PRC arbitration law, but also amendments to the civil procedure law and robust support from PRC court system. And even if this new mechanism is put in place, I don't think it will diminish Hong Kong's unique role, because as Niels just mentioned, I think this is only the amendment, the arrangement is only a plus to the various advantages of Hong Kong as a widely welcomed international arbitration hub. And still, as compared to other international arbitration jurisdictions, the advantage of the arrangement remains there. It is still an advantage over other international arbitration jurisdictions. So that's my understanding, Anton.
Thank you very much, Chun Gang. So we have received a flurry of questions from the audience, and I'm going to exercise my moderator's prerogative to select a few of them to pose to the panel. All of the questions are quite interesting. Some of them I think are a little bit more closely related to the specific subject matter of our discussion today than others. Let me start out with a question for Sarah. How do the mainland Chinese courts communicate with HKIAC if they want to ask HKIAC to provide more information on the applications?
Yeah, that has typically been an oral communication to the applicant, which is then passed on to HKIAC.
An oral communication to the applicant, and then the applicant then makes a submission to HKIAC,
exactly.
or
so typically it will be something that's raised during the proceedings in mainland China, and then that will be conveyed to us by the applicant, and then we will respond to the applicant.
Okay, that's quite interesting. Thank you. A question for the panel here. How does the mechanism of emergency arbitration interact with the arrangement? And I would suggest maybe we start with either Sarah or Dr. Yang Ling if you're there, or Chun Gang. I see you unmuted yourself, so why don't we go to you?
Okay, Anton. Because we are talking about the interim measures granted by mainland court in aid of Hong Kong arbitration, so we were frequently asked by our clients that even absent such kind of arrangement, is it possible to apply for an interim measure or to enforce interim measure imposed by the Hong Kong tribunal? I think this question will also include emergency arbitrator decision. The answer is no. Because the emergency arbitrator decision is not regarded as a final arbitral award, so it cannot be enforced in the mainland as arbitral award under the New York Convention or the arrangement between Hong Kong and the mainland on recognition of arbitral award. That's why the arrangement we are talking about today is so valuable. Yeah.
So in other words, the interim relief from the PRC courts effectively becomes the exclusive or is the exclusive mechanism for obtaining urgent relief on the ground in mainland China. Is that the right way to understand that? If you're dealing with a Hong Kong seated arbitration?
Yes, I think so.
Great. And,
if I could just add to that, Anton, from the perspective of the user, we understand those things as alternative choices. The use of an emergency arbitrator is often seen as a suasive device, in other words, something that we believe will encourage a party to comply either voluntarily or frankly, out of concern that the tribunal ultimately will view disfavorably further actions taken by that party, whereas the application for interim measures, whether in this context or in any other, is one where we believe the party can't be swayed and compulsory action must be taken.
So depending on whether you think there will be voluntary compliance or whether you're actually going to need a binding enforcement mechanism in China. Very helpful. Thank you, Carl.
I would just
please, go ahead.
Quickly add to that as well that the fact that it's quite that decisions by emergency arbitrators are not enforceable is not unique for mainland China. Of course, it's the same in many jurisdictions around the world, and they are enforceable in Hong Kong, but that's an exception really to the norm. So it's not at all uncommon, as we see it, that parties try parallel tracks and go to the courts for ex parte relief and to an emergency arbitrator at the same time and see who gets to a decision first when that is needed. So they are not at all exclusive.
Thank you very much. Great point. And even within the United States, there are differences in the 50 different states as to whether an emergency arbitrator order will be enforced. Maybe time for one final question. This is an interesting one. The questioner says, I recently read articles concerning the debate over whether an arbitral tribunal can award costs incurred for obtaining interim measures in ancillary court proceedings. So let's say that we take advantage of the arrangement and we go and we get an interim measure from a PRC court. Can we then go back to our, when we go back to our HKIAC arbitration, should the arbitral tribunal, or does the arbitral tribunal have discretion to award us the cost that we incurred for that ancillary court proceeding? Any views from the panel on that question? Like maybe Niels, you're still showing on my screen, so I'll start with you.
It's an interesting one, and I must admit that I haven't thought about it. The power of the tribunal under the HKIAC rules, as well as under the HKIAC, as well as the Hong Kong arbitration ordinance, is one to order costs that relates to the costs of the arbitration proceedings, and that certainly covers any interim measures ordered by a tribunal or an emergency arbitrator in relation to the arbitration proceedings. Whether that can extend to court-ordered interim measures, I think, would be a stretch based on the wording of the ordinance. But I must say that I have not analyzed that question in detail.
Okay, well, it's an interesting question, and one that it sounds as if there's some debate in the commentary over how that should be interpreted. So we're at the end of our time. Before we close, I want to just do a 1-minute lightning round question to each of our panelists, just for the sort of takeaway here. I know we've covered a lot of ground. At the end of the day, our clients and often our corporate transactional colleagues are mainly interested in a bottom line recommendation. Should we agree to Hong Kong or some other place as the seat of arbitration in our arbitration clause? So what specific advice are each of you offering to parties or clients to address the various shifting landscape that we've been discussing today? And I'll kind of just go around the table for a few quick words from each of you, and Niels, I'll give you the privilege of going first again.
Thank you. Something that we tell our clients is that, you know, when you have a deal with a clear China connection, you will have to think very carefully before choosing any other seat than Hong Kong with the arrangement, because you are really giving up an advantage that is substantive, that goes beyond, you know, the mere preferences when it comes to seats that are otherwise more or less similar. It is a substantive difference, a substantive benefit that you are giving up by not choosing Hong Kong as the seat. So therefore you must have very clear and good reasons for doing so if you are going to Singapore or London or Paris or Stockholm or elsewhere in a China-related deal.
Thank you, Niels. Carl, anything to add?
Yeah, I'd echo that, but I'd also then extend it over time. That's not just a consideration that takes place at the moment of contract drafting, but may even be a reason to consider an ad hoc agreement that would replace a contractual agreement that may have pre-existed this arrangement, or pre-existed advice being given on this arrangement. Parties should think actively about the way that they can both benefit from this arrangement, and frankly try to reach a settlement of the dispute that is at least cost and with greatest preservation of the relationship. I see this arrangement in those terms.
Thank you very much, Carl. Chun Gong?
Okay, you know, as a Chinese lawyer, I have handled a lot of disputes over or surrounding the validity of arbitration agreement, the scope of arbitration, the seat of arbitration, etc., especially due to the significant difference between the PRC arbitration law and Hong Kong arbitration audits. You know, the legal concepts and definition and legal requirements of arbitration agreement, etc., are so different. So I strongly recommend the users of HKIAC arbitration to use the model arbitration clause of HKIAC, which can, to a large extent, avoid many unnecessary disputes. Yeah.
Excellent advice. Excellent advice. Thank you, Chun Gong. Sarah, I think you have perhaps some bias on this question, but please go ahead.
I think so, all bias aside, of course, but I think, you know, all things being equal, in Hong Kong as a seat amongst, in comparison to the other major seats, it is equal. So for me, you know, we watch these applications come through and we see them be successful, and to me, it's not so much a game changer, it's really a no-brainer. It's obvious, so that would be what I would call it, no-brainer.
Excellent. Thank you very much, Sarah. Thank you to all of the panelists. Thank you to Dr. Yang for the overview presentation. Thank you to HKIAC for hosting, and thank you to all of the participants for joining us today. We wish you a wonderful Paris Arbitration Week. If there were other questions that you had that we didn't have an opportunity to answer, please feel free to reach out to us directly after the event. Thank you very much. Goodbye, everyone.